Hey there. This is known unscripted iota. It truly is an ominous day, and but it's not a hopeless day. So we're, I read the leak when the draft leaked. I glanced over it. I read it. I have not gone and read the whole decision. Uh, but I read it when the draft was leaked. I talked about how it was. It's just, it's really an awful opinion. It's really, it's up there with Dred Scott, Citizens United, Plessy v. Ferguson, now Dobbs v. Jackson. Uh, there are many scholars who are going to be doing a lot of analysis and pick apart everything that everybody said in that opinion, including the dissents. And the dissents are important because they come back around decades later. Because it's judicial dicta, it's of the highest order. It may not be the rule of law, it may not be binding precedent, but it's Supreme Court justices' opinion of what is happening. So there is weight to dissents and concurrences. That goes to say that Clarence Thomas's concurrence that said effectively that gay rights and right to contraceptives may all be out, on their way out. Incidentally, he didn't say anything about loving, but that's also on the chopping block. I don't know how he's going to reconcile that. Maybe that's the whole plan. Maybe Clarence is, drumming this whole thing up so he can finally end up undoing loving Virginia and rid himself of Ginny Thomas. I don't know. That's the most optimistic analysis I have of that. But that's where we are at the moment. The alert on substantive due process rights is at its highest. And I've talked about substantive due process before, but I will do my best to condense this massive history of substantive due process. I'll start out by saying that as we stand today, one of the pillars of substantive due process have been knocked down. Roe versus Wade was one of the pillars of substantive due process body of law. And today, one of the pillars of this body of law has been struck down. The other three are Loving v. Virginia, Griswold v. Connecticut, and Obergefell v. Hodges. Now, Griswold v. Connecticut, the right to contraceptives, is the landmark case that established and that brought over substantive due process from a very different application of that body of law purely for contractual rights. And I don't know much about specifically the case about Loving, but I can tell you it's interracial marriage, right to marry, and then Obergefell is the extension of that to say that same-sex couples have the right to marry. And it's a really confusing body of law because it's not enunciated, it's not codified, it's just been in judicial dicta and majority and minority opinions for the last 100 years. And I think that not codifying these laws is perhaps Congress's biggest failure in the last 100 years. These are individual liberties. These are unenumerated rights that, by way of the 9th Amendment of our Constitution, the 10th Amendment of our Constitution, the 12th Amendment of our Constitution, the 1st and the 2nd and the 3rd and the 4th and the 5th and the 6th and the 7th and the 8th, all of these amendments have elements of privacy attached to it, elements of autonomy attached to it, elements of liberty attached to it. You know, those foundational principles without which the logic that drives these amendments to our Constitution wouldn't happen. You know, the originalist position is that whatever is written in the Constitution, that's it. Well, it's written in the Constitution that you can have amendments to the Constitution. And when an amendment comes out of the Constitution, that becomes that's part of the Constitution. How the moment then the Bill of Rights was passed, there was no longer by that originalist logic, the Bill of Rights doesn't have any weight because it's not part of the Constitution. I mean, right? I mean, is that where we're going? Because the Constitution provides for amendment. So you're saying that you're kind of shooting yourself in the foot if you're saying that it's only whatever's only in the Constitution, and then saying, oh, well, provision for amendments is in the Constitution, and then saying, okay, well, the amendment has to go through the state process and all of that, and okay, we'll take the amendments. Okay, we'll take the amendments. Then you keep on bringing the amendments that are fundamental, but then you deny the whole process by which an amendment was brought into reality to begin with. The need for recognition of these liberties, the need for protection, the need for expansion of individual rights, because the Constitution largely provides for the government and not about anything about what the Constitution doesn't say in its text is what the rights of the people are. And that's why the Bill of Rights was enunciated and brought in. The Constitution was written with provision for amendments. The amendments are drafted, ratified, and then they become part of the Constitution. Well, the amendments are adopted on the basis of inherent need, without which the whole purpose of the Constitution would be frustrated, because what's the whole point of having the Constitution if people have no rights? So the First Amendment has rights. Second Amendment has privacy rights. Second Amendment has privacy rights. The First Amendment, privacy rights, your choice to speak, to engage in whatever, exercise whatever religion you want. You have to choose to do that. Otherwise, if you don't have that choice, then you don't have the choice to do anything. If you don't have the choice to speak, if you don't have the choice, the Second Amendment is about your defense. When you feel that your privacy is being threatened, the Third Amendment is about your privacy and your safety. So, because when it was drafted, it was at a time of war, when the Third Amendment was drafted, and they would quarter soldiers in houses. And there were instances of assault. There were instances of what today would be considered war crimes, rapes, and that's what happened generally when soldiers of war quartered in residential homes. And so there's a huge privacy element to it, huge bodily autonomy element to it. Mind you, at that time, women were chattel, meaning they weren't people, they were property. So they would just have, upend women's suffrage also, upend. I mean, where is it going to stop? You have your Fourth Amendment right to unreasonable search and seizure, which has been stripped naked after Terry v. Ohio, and onward and onward and onward. But that has led to what we now have as stop and frisk. It started with Terry v. Ohio, reasonable suspicion. You threw probable cause out of the window by continuing to uphold. Then after Terry v. Ohio, you were like, oh, no, we fucked up. So we're going to go ahead and do the Miranda case and talk about Miranda rights. Well, just 2 days ago, they said, no, you don't really have to explicitly say that, give Miranda rights. Well, I'm going to do another special episode about that. So they're going after your right against unreasonable search and seizure by saying that the state can go ahead and not remind you of your Fourth and Fifth Amendment rights against self-incrimination. And Miranda goes to Fifth Amendment rights of self-incrimination, right to counsel. And so there's a privacy element there that you don't want to say anything that would incriminate you. You don't want to say. And they have just 2 days ago just effectively said, the police, the state doesn't really have a duty to remind you of your rights. You should know your rights. So know your fucking rights. I mean, a need for education has never been more of an imperative, more of a necessity. And that gives you some idea of why the Republican Party will not fund education programs. Or education funding is not a priority for them. Pay for it, in their opinion. If you can pay for it, go get it. Because they want to privatize it. They want to privatize prisons. They want to privatize education. So only the people who can afford it. So you have to claw up the rungs like they used to do in feudal society of kings and queens. And you wonder why they are still bootlicking Donald Trump. But that's not our country. You cannot say 100 years of judicial dicta just goes out the window because just one day you decided to look at only one slanted way of looking at history. And I don't know, in my mind, you don't have a prohibition of something if that thing isn't in existence. The way that the gay rights, the cases came up, that's one area that I specifically know. So I'll talk to you about that. I don't know much about loving. I don't know much about. No, I don't know a little bit about Griswold, but Griswold is a landmark case, like I said, about these. Oh, so when you get to the Sixth Amendment against double jeopardy, the Seventh Amendment against of your civil right to civil trial, these are all rights to protect your Eighth Amendment against unusual cruel punishment. All of these rights are they involved inherent elements of autonomy, of privacy, of liberty. And as serious as this conversation is, you see what's happening behind me. That's some levity for us. Now, and then you have the Ninth Amendment, right? It says that any of the things that we haven't said here, obviously I'm paraphrasing, in these rights, doesn't mean that there aren't more rights. And then the 10th Amendment, rights that we haven't said here are vested to the people, to the states. The states' rights. And then there are several other amendments. And then there's the 12th Amendment. And then there's the Equal Protection Clause. And then you have, so what today's Dobbs decision has done has attacked all of that. Because for you to say that we can't move forward and build on this momentum of expanding our rights, and the Supreme Court shouldn't guide that way, then you are on the wrong side of history. When Justice Kennedy wrote the Obergefell v. Hodges opinion, he talks about emergent rights. And I'll go back to that prohibition part of it. So this is where we're going to tie it up. Not the whole thing, but this may be a little bit longer episode. So there was really no laws on the book about prohibiting gay behavior or gay marriage. There were sodomy laws all over the place. But in the late 70s, there was no prohibition of marriage. Marriage didn't have a definition. There were no explicit marriage laws that many of the states had before Obergefell came. Now, in the late 70s, a couple wanted to get married in San Francisco. That's where that fervor came up. It started brewing this anti-gay sentiment. Now, mind you, it doesn't really matter for the Republicans to care about gay marriage or care about any of these social issues. They are just the biggest weak points, your biggest vulnerabilities. And the places where you're most emotional, the places where you spend the most time thinking or being scandalized by, they aren't the topics that put food on your table and a roof over your head. These are the topics that deal with your reputation, deal with your culture, deal with our identities, deal with how we live our daily lives, deal with our privacy and our daily usages and our relationships. They aren't this. That's what these rights are about. And as such, it started brewing that this may be a good way to distract the populace enough to create division. And I'm saying this because the substantive due process body of law comes from a very conservative court that recognized the contractual right that you have a right to contract. It's not enunciated that individuals have a right to contract, but I mean, we have the right to property, and how would you get to it? Um, and there's so this whole like, but I mean, it's been years and years that I've gone to that Lochner era cases or whatever those case names are. Um, but so this idea of this back to the gay rights part of it. Um, when you have so because of that case in the late 70s in San Francisco, there started to be state bans. Laws came out, and then there were cases: Bowers v. Harvick, Romer v. Evans, Lawrence v. Texas. Lawrence v. Texas was a case that before that, Bowers v. Hardwick and Romer v. Evans, they effectively just said no, there's no such thing as gay rights, whatever. you know, like uh, in Lawrence v. Texas, they said that there is a rational basis, which is what Roe versus Wade has been brought down to, from strict scrutiny to rational basis, which is, I mean, which is, it's blasphemy. So after Lawrence versus Texas, which was 2001, there was a huge amount. When did Oberfeld come out? I think 2017. There was like 17 years of heavy activism. And I know this because I was part of that activism in a very droplet sort of way. Everything from marching to going to conferences as students in college, to marching in parades, to then me studying specifically gender history, history of masculinity in America, and American history, and American race and gender, and then onto law school, focusing on constitutional law. And so, and going into substantive due process, because it was personal, right? Because when I went to law school in 2005, there was nothing. I think when 2005, Don't Ask, Don't Tell was still law, maybe. No, I don't know. It's been so long now. I'm not an active activist anymore. I don't wave flags down the street and volunteer at nonprofits, because I'm currently not in a position to do. But what I am in a position to do is explain to y'all what is happening, because they don't want you to be educated about it. They don't want you to know about it. They want to push you by mislabeling and misguiding and misdirect you, and it's abhorrent. And so I'm doing my best to do what I can, and clarify as much as I can for you in as simple as terms as it possible, because this is heavy topics and this is large topics. So yeah, after Lawrence versus Texas, there was so much activism that there were many states that recognized the right to marry, and slowly we came upon Perry v. Ohio. Perry v. Ohio, it recognized gay rights, lifted it up higher than Lawrence v. Texas, but it didn't do enough. It didn't recognize gay marriage. It skirted the issue. And these are big cases. I'm not going to go into specifics. Then came Oberfeld v. Hodges, and in his last major opinion, Justice Kennedy wrote that there is a right to all people to marry. Same-sex marriage is a constitutional right. It's part of the emergence rights theory that we expand rights. The Constitution, before Dobbs v. Jackson today or yesterday had never taken away a vested fundamental constitutional right. A fundamental constitutional right is one that gets strict scrutiny in the eyes of the court and the eyes of the law, and laws are designed to adhere to those strict scrutiny, which that the state has to have a substantial interest in drafting a law to limit that particular right, as opposed to a legitimate interest. And that's like my professor said that it was like a sort of 70-30. It's strict scrutiny is like a 70%. Like that's how strong your individual rights are at strict scrutiny. At rational basis, they're at 30%. So don't think that there is no right. They have still some, like, it's not that it says there's no conference of right, but then there's rational basis. I mean, the opinion itself is just bunk and poorly written. So they didn't say, oh, we're just going to say states can write whatever they want. It's rational basis. It has to be a legitimate state interest, right? So at least they didn't go far to whatever the hell you can do, whatever the hell you want. But individual rights right now, when it comes to reproductive freedom in the United States, is at 30%. Individuals have 30% versus the state having 70% of the say in your reproductive freedom, women's reproductive freedom, and it affects men too. Don't think your mothers and your sisters and your wives and your girlfriends, all of them are affected by this. Every single one of your decisions will be affected by this. There will be so much strife because of this one decision. And then after, so what happens now? Roe v. Wade is gone. I mean, it's surreal to say that, right? It's surreal. You go into constitutional law, you learn about one of the first substantive due process cases you learn about is Roe v. Wade. You learn about Griswold v. Connecticut because it is the big case that establishes and brings this right over. And I want to keep saying that. I want to remind you that this was substantive due process wasn't a body of law that Griswold v. Connecticut just thought out of the out of nowhere. It came out of substantive due process body of law way back from the Lochner era that talked about the ambit of each of the rights that are enumerated in the Constitution, the penumbra of the rights, or the basis, the foundation of the enunciated rights, as I said earlier about each of the amendments. Those are enumerated rights, and a republic, a conservative court established that there is an ambit of these rights. They don't exist in a vacuum. It was simply transferred over from contractual rights to individual rights by Griswold v. Connecticut, and then onward to expansion of individual rights. If you go to legal cases before the 1960s, I don't know how many individual rights cases you will find. But without individual rights, without the court guiding society out of the archaic way of thinking, there would be none of the progresses that we have experienced today. We wouldn't be the society that we are today if women weren't given some dignity. The women never, even to this day, even after having the right to vote, have been given equal protection under the law. It's as true as it can be. Equal protection under the law. If you go by equal protection under the law, and if we have the right to property, then why aren't women paid the same as men are? Isn't that unequal? And we have the right to life, liberty, and property. They're going to say we're going to have the right to life, liberty, and the pursuit of happiness. What is the pursuit of happiness? Property. How do you get to happiness? I mean, in the material world, unless you're going into meditation and renouncing everything, and then the whole logic is different. But we're not talking about that. We're talking about living in a functioning society where you have to work, where you need money. So how do you get to that? If we have that fundamental right, and then there's the equal protection, why aren't we getting equal protection for women? And today, another one of those equal protections were taken away. And it's so important today. It is so important that you start learning about this body of law, substantive due process. Because if you don't, the next case they're going to go after, and I'm telling you, somehow, somewhere, they're going to find a way to take a case up to the Supreme Court that will attack the right to contraceptives in Griswold v. Connecticut. It's going to attack Oberfeld v. Hodges, the right to same-sex marriage. And I would not be surprised if they didn't go, if they went after Loving, which is interracial marriage, right to marry. And then, I mean, if they went after Griswold, then the rest of it is just done. The right to contraceptive, focus on that. It may seem like nothing. The right to contraceptive, that includes your birth control, that includes condoms, that includes any sort of prophylactic. So just you got to go, like, Google Griswold v. Connecticut, Supreme Court case, 1965. I believe that's when it came out. Okay? Read that case. And then the last case, the second case you should read is Oberfeld v. Hodges. Because that is the first case, Griswold v. Connecticut, of substantive due process body of law, and Oberfeld v. Hodges is the last case. You will get all of the case references that you need in those two cases. And the evolution of this body of law from 1965 to 2022. So I'm going to leave it at it. It's been 30 minutes. I've been blabbing about it. I don't know if any of this is going to make sense to any of you, but maybe I'll get clips out and some of that can make sense. I do this live stream because of a train of thought, and the train of thought is important because we have to be ready at all times with what words we use, how we communicate. We are coming up into a world, we are an advanced democracy. You can't compare what happened in Afghanistan with what happened in the United States. You can't compare what's happening in Ukraine with the United States is the oldest constitutional republic in the world. Britain is constitutional monarchy. France is on its 6th constitution because the way that their constitution is drafted, I think 6th, they can dissolve the constitution completely. We can't do that. That's not provided for in the constitution. Otherwise, don't you think that they would have done it? They're trying so hard to get rid of all the amendments. I mean, this is where this is headed. I'm forecasting, if this is the trend downward, if this is the trend and there is no up and we don't wake up, this is going to end with you not having anything in the Bill of Rights also. That's how extreme I'm going to predict this. But that's 100 years down the road. It's not going to happen overnight. But the next stop is one of the other three cases: Loving, Oberfell, Griswold. My guess is Griswold. So if you are to read four cases: Loving v. Virginia, I think that's the name of the case. Please pardon me. Type in Google interracial marriage, Supreme Court of the United States. Whatever comes up, I think it's Loving v. Virginia. I know it's Loving, but I don't know if it's v. Virginia or some other state. I forget. I don't know how can I forget, but I haven't been practicing for over a decade, right? So then you go to Loving, you read Roe, despite the fact that it was just overruled, and you read Griswold v. Connecticut, and you read Oberfell v. Hodges. Then if you want to get into it, you read Casey v. Planned Parenthood. You read Carhart v. Gonzalez, which is late term abortion case. You can read Lawrence versus Texas, Bowers v. Evans, Bowers v. Hardwick, Romers v. Evans. You can read Perry v. Ohio, Lawrence versus Texas, I think, and then Oberfell v. Hodges. These are the relevant cases that, as far as I can remember, that are major, that needs to be read at the moment, and people need to understand what we're dealing with. Okay. Now I'm gonna get to this is gonna segue into how I think the protest should happen. You have to understand something. It's both courageous and impulsive to go out onto the streets with a sign and protest and spend your time and your energy on that outward activism that calls on people in power to do something. And then there's the other way of protesting. And you know, I'm going to start with a story, and then I'm going to go to let's see where this train of thought takes me. I don't know, everybody knows Medusa, the story of Medusa, right? Medusa is a beautiful Gorgon, a beautiful woman. Gorgons were women with power, who were sort of, kind of like, whatever. They were powerful women, beautiful, powerful women. Medusa was raped by Poseidon, who was the god of the seas, and raped in Athena's temple. And Athena misunderstood and cursed her, and said misunderstood that they were just having consensual sex, and later found out that it was rape, and didn't really care because she was Athena, and cursed Medusa to say that anybody who looks upon your face, looks upon you, turns to stone. Well, that didn't really, and over that story has drawn out, and people have had Medusa with snakes for her hair, but Medusa is always beautiful, and you have to make sense of that story. And I always try to ask why people say tell stories. People, what's this? So when I learned about Medusa's story, about the rape, about then this is the hierarchical admonition of Medusa, and then the curse that anybody that looks at you turns to stone. And looking from the vantage point of somebody who has been raped before, I'll talk about that in another episode. Let me tell you something. If my eyes could turn aggressors to stone, I would take it as a blessing, not a curse. And that is where I want to start with how to protest. You're like, how can you turn somebody to stone? You can't turn. Well, there are many ways to. We call them giving the cold shoulder. And we call it nonviolent non-cooperation. We call it, we're going to quietly mobilize armies of women and sexual minorities and marginalized people who see this to be a threat to our rights as individuals in this republic of the United States. We have to quietly educate ourselves. We have to quietly, and we don't need to go out onto the streets. In fact, the reason why I brought up this freezing them, turning them to stone, is by saying that become nonviolent. Stop cooperating. Stop disclosing and expressing what you think onto the streets. Go completely quiet. And then go inward. Find your group of friends. Find your group of people. Read the right books. Read the right cases. Start movements in your neighborhoods and your cities and your towns and your city councils, and get leaders and speakers, public speakers in your groups elected into council seats in droves. You know what they have done? They've done this for decades to get to where they are today, to erode individual rights to the point that they did with one fell swoop. And it's going to take us time to get back on our feet, but we will get back on our feet because the numbers are on our side. The overwhelming majority of Americans are liberals who support the right of a woman to decide whether or not to terminate her pregnancy. Overwhelming majority. As Republicans would understand it, filibuster-proof majority. So go inward into your safe zones and start expanding your understanding of your own rights, because they have already started taking them away from you. It has started with the unenumerated fundamental constitutional right of a woman's right to choose whether or not to terminate her pregnancy. And I am telling you today that if this is the direction our country is allowed to go, by way of our apathy and by way of our laissez-faire attitude about going and voting, then if this is the direction we're going to go, it's going to end with you not having the right to speak. And your First Amendment right will go away, and you will not have the right to exercise your religion. Talk about the nationalists. They're coming for you, the evangelical nationalists. I'm sorry to say, buddy, they're going to come for you too. The only right they're going to keep is the Second Amendment right. They're going to let the military into your houses. They're going to arrest you without probable cause or even reasonable suspicion because somebody in power wants you arrested. They're not going to give you due process of law. They're going to try you over and over for the same crime, even if you have committed and paid for it once. They're not going to give you the right to trial, even in civil court. And cruel and unusual punishment, they're going to bring back quartering. They're going to bring back public floggings. And the Ninth Amendment, no, sir, you don't have, no, ma'am. Oh, ma'am, what ma'am? You're chattel. You're property. You don't have rights. Yeah, you may have the right to vote, but good luck getting there. Because the right to vote is now codified into law, right? So it's going to take a lot. And if we keep going this way, I'm telling you, they're going to go after the Voting Rights Act. They're going to go after any sort of rights. I don't know, Voting Rights Act is not even out past yet. So that's why you see why they're going after it. You see why they won't let it happen is because, and I'm telling you, I am telling you, it has started today with the right to choose. It will end if we don't stop them with the right to speak. Is that where you want your country to go? Is that where our country needs to go to be called a more perfect union? I don't want to be great again. We were never really great. Every day that we took a step forward, we were becoming a more perfect union. We were becoming great. And today we've taken a massive step back. So I would say, yeah, go out and walk the streets one day, but then get to work. Get to work to register to vote at every level, from the county level to the federal level. And do it quietly. You don't have to tell them what you're doing until it's imminent, until it gets so close that, and they're still not aware of what you're up to. I'm going to be direct and say, don't be litigious. Don't take every case to court just because you see a liberal judge in your district or a liberal judge in that appellate circuit, federally speaking, even in the state levels. Unless you're in a favorable state that understands there is such a thing as individual rights. Because the central ruling of Dobbs v. Jackson is that we are returning the right to the people and their elected representatives. Okay, so you're acknowledging that people have rights, great, and you're acknowledging that these rights, these are unenumerated rights, they need to be codified. Okay, we understand that. But you're also saying, by making that statement, that you acknowledge the Ninth Amendment, that rights that are not enumerated in the Constitution, I'm saying arguably you believe that, the Bill of Rights is part of the Constitution because it was ratified for now. And so you just, that's how convoluted their reasoning is, right? Because it mixes you up, it messes you up, and it's messing me up because I'm going on close to an hour now. So yeah, I'm done. Take care.